Just a second. We are live. We can stop.
Yeah, so is everyone here? Yeah, so sir,
Yes.
should I begin with the
Yeah,
webinar?
you can start. Yes, yes, you
Yeah,
can
okay.
start.
So good morning, everyone, respected speaker, participants, and the fellow members of Law Tales. I welcome everyone to the webinar on ADR Evolution in India over time. So about the webinar will be unfolding the wide areas of alternative dispute resolution, taking into consideration the development from ancient times to the modern one. We also intend to educate and equip them with the tool of legal awareness to become responsible citizens of the country. Now, about the organizers. So, Law Tales is the perfect platform to fulfill your academic needs. We are here to assist you in all the ups and downs of your academic profile. We, as a community, work to make the process of grabbing knowledge a piece of cake and to help you overcome all the obstacles in life. So, here I would like to talk about the speaker. So, Dr. Romesh Gautam is a senior advocate at Supreme Court of India for the last more than 35 years. Sir has completed his LLB, LLM, and LLD PhD in law and has also been awarded honoris causa by 5 prestigious universities. Sir is a visiting professor in many universities in India and overseas. Sir has been Advocate General for 7 states. Sir is an endorser for climate principles for enterprises. Answer has also conducted several cases of international and national importance. His clients include central ministers, governors, chief ministers. Sir has also advised many foreign bankers, including KfW Germany, Nordic Investment Bank, etc. Now who have accepted his advice and granted huge amount of loans to government of India in 1994. Sir is the first Indian lawyer who has conducted international level dispute review boards, alternative dispute review cases for which Sir has entered in the Limca Book of Records. Sir is the third lawyer in whole world to conduct ADR cases. Sir has acted as an arbitrator and also as a counsel in many number of arbitration cases in India as well as overseas. Sir is known as a personality in field of law in India and abroad. Sir is Padma Shri, President of India awardee, Limca record holder, professor of law, author, writer, motivational speaker, political strategist, and analyst. Sir is also the senior arbitrator for several organizations. Sir is the global chairman and director general for the International Human Rights Organization, World Chairman Legal, All India Council of Human Rights, Liberties and Social Justice, Chairman for Hindu Sanatan Vahini, Chairman and National Legal Advisor for ABMS, National Legal Advisor for Sri Parashuram International, Fellow and Senior Member of Indian Council of Arbitration and Bar Association of India. Recipient of 78 national and international awards, Sir holds the title of International Jurist, Barrister in Inns of the Court, London. Sir holds awards such as Pride of Nation, Bharat Gaurav, in National Law Day Award, Best Jurist, Pride of India, Delhi Ratna, Haryana Gaurav, Human Rights and Social Rights Activist also. Thank you so much, sir, for dedicating your time here.
Yeah.
Now you can continue with the webinar, sir.
Yes. You can. Thank you so much, Shatakshi. And I thank the organizers that they invited me. Of course, I remain busy with certain things, and it is difficult to take out time. But then 9th was the suitable date. Probably it was meant for you people, so I agreed on 9th, and today I am before you. Today's topic is a very, very important topic about ADR. If we look at the topic today, that what was the system of ADR in ancient time? How this ADR process, ADR thing has developed? Was it there in ancient time or not? And if it was, then it was in which form? So that is something which is very important to know. And I would here deliberate about the fact that ADR was very much in existence even in ancient time. even in Gupta's period, even in Mughal periods. I will come to all these things. And then, of course, at today's time, what is the form of ADR today? All those things I'll be discussing, and then you can ask questions, whatever questions you want to ask. At the end, you can write down your questions in between, and whenever this my lecture finishes, you can ask those questions. Okay, so I'll start with the ADR. To understand ADR, what we need to do is we have to know what ADR is. It basically is a method of resolving dispute without resorting to the court processes. We don't go to court and resolve the dispute. That is ADR, that is alternate dispute resolution. Sometimes public courts may be asked to review the validity of ADR methods, but they hardly overturn the awards given in ADR or the decisions of the award, and provided the disputing parties they form a valid contract, they form a valid agreement between themselves. If we prove that, then it is very difficult for the courts to set aside the award or the decision of the ADR. Alternate dispute resolution refers to any means of settling disputes outside the courtroom. ADR typically includes early neutral evolution, negotiation, conciliation, mediation, and arbitration. As the increasing court queues, rising cost of litigation, and time delays continues to plague litigants, more states have begun experimenting with ADR programs. Some of these programs are voluntary, some of them are mandatory. While the two most common forms of ADRs are arbitration and mediation, negotiation is almost used in each and every case, because that is what we do prior to approaching the arbitration or media, mediation. Negotiation is always there. Negotiation always exists. It is the preeminent mode of dispute resolution. Negotiation allows the parties to meet in order to settle a dispute. The main advantage of this form of dispute settlement is that it allows the parties themselves to control the process and its solution. Alternate dispute resolution mechanisms have become more critical for businesses operating in India as well as those doing businesses with Indian firms. Alternate dispute resolution is necessary as a substitute to existing method of dispute resolution, such as a litigation, conflict, violation, or physical fight or rough handling of the situation. It is a movement with a drive from evolving positive approach and attitude towards resolving a dispute. In the subsequent part of this webinar, now we will discuss about the evolution of ADR and its present scenario in the Indian context. It is very important to understand. It is very important to understand that alternate dispute resolution is not something new and has been around in our country for centuries altogether. In India, the law and practice of private and transactional commercial disputes without court intervention can be dated back to the ancient time. Arbitration or mediation as an alternate dispute resolution by municipal courts has been prevalent in India from Vedic times. The earliest known the earliest known treatise is Bhadranayaka Upanishad, in which various types of arbitral bodies, the Puga, the Sreni, and the Kula are referred to. These arbitral bodies, known as panchayats, dealt with variety of disputes such as disputes of contractual, matrimonial, and even of criminal nature. The disputants would ordinarily accept the decision of the panchayat, and hence a settlement arrived consequent to conciliation by the panchayat would be as binding as the decision that was on clear legal obligations. The Muslim rule in India saw the incorporation of the principle of Muslim law in Indian culture. Those laws were systematically compiled in the form of a commentary and came to be known as Hidayah. During Muslim rule, all Muslims in India were governed by the Islamic law, the Sharia, and contained in the Hidayah. The Hidayah contains provisions for arbitration as well. The Arabic word, the Arabic word for arbitration is takhim, while the word for the arbitrator is hakam. An arbitrator was required to possess the qualifications essential for a qazi, an official judge presiding over a court of law whose decision was binding on the parties, subject to legality and validity of the award. The court has the jurisdiction to enforce such awards given under Sharia, though it is not entitled to review the merits of the dispute or the reasoning of the arbitrator. ADR picked up a pace in the country with the coming of East India Company. The British government gave legislative form to the law of arbitration by promulgating regulations in three presidency towns, Kolkata, Bombay, and Madras. Bengal Resolution Act 1772 and Bengal Regulation Act 1781 provided parties to submit the dispute to the arbitrator appointed after mutual agreement and whose verdict shall be final and binding on both the parties. These remained in force till the Civil Procedure Code 1859 and were extended in 1862 to the presidency towns. The Gupta empires had a separate and distinct judicial system. At the lowest level of the judicial system was the village assembly or the trade guild. These were the councils appointed to settle the dispute between the parties that appeared before them. There were separate councils appointed to decide various matters that came before them. Thus, if people could not reach to any amicable settlement, it was resolved by the councils. During the Mughal dynasty, most villagers resolved their cases in the village courts itself and appealed to the caste courts. The arbitration of an important impartial umpire, who was known as salis, or by a resort of force. The Maratha empires established panchayats. They were the first instrument of civil administration of justice under the Marathas to adjudicate cases of simple and minor nature. The disputing parties were to sign an agreement regarding the abiding of the rules and regulation of the panchayat. It was up to the panchayat to study the case and pass its judgments impartially or without any bias to any party. A Mamlatdar was the higher officer in the succession of judicial administration was to confirm the judgment. Generally, the Mamlatdaran and the Panchayat used to adjudicate the cases which were upheld by the Maratha government. With the advent of the British Raj, these traditional institutions of dispute resolution somehow started withering and the formal legal system introduced by the British began to rule. Alternate dispute resolution in the present form picked up pace in the country with its creation of Bengal regulation. The Bengal regulations were designed to encourage arbitration. After several regulations containing provisions relating to arbitration act 8 of 1857 codified the procedure civil code except those established by the Royal Charter, which contained sections dealing with arbitration in suits as well as sections which provided for arbitration without the intervention of the court. Thereafter, the Indian Arbitration Act 1899 was passed, which was based on the English Act by the same name. It was the first substantive law on the subject of arbitration, but its application was limited to the presidency towns of Kolkata, Bombay, and Madras. In 1908, Civil Procedure Code was reenacted. The code made no substantial changes in the law of arbitration. The Arbitration Act of 1940 was enacted, replacing the Indian Arbitration Act of 1899 and contains parts of the Civil Procedure Code 1908. It amended the consolidated it amended and consolidated the law relating to arbitration in British India and remained in a comprehensive law on arbitration even in the Republic India until 1996. I had conducted cases under 1940 Act, several cases under the old Act of 1940. To keep pace with the globalization of commerce, and old Arbitration Act of 1940 is replaced by the new Arbitration and Conciliation Act 1996. Settlement of matters concerning the family has been provided under the amendment of the Code of Civil Procedure in 1976. Provisions are made under the Special Marriage Act 1954 and the Hindu Marriage Act 1955 for making efforts for reconciliation. Under the Family Courts Act 1984, it is the duty of the family court to make efforts for settlement between the parties. Introduction of Section 89 by way of 1999 amendment in the Civil Procedure Code 1908 is a radical advancement made by the Indian legislature in embracing the system of courts referred alternate dispute resolution. Legislation of ADR in India. If we talk of Civil Procedure Code 1859 and its section 312 to 325, which dealt with the arbitration in a suit, while section 326 and 327 provided for arbitration without court intervention. The Code of Civil Procedure 1908 repealed the Act of 1882. The Code of Civil Procedure 1908 had laid down that cases must be encouraged to go in for ADR under section 89 within bracket 1. Under the first schedule, Order 32A, Rule 3, a duty is cast upon the courts that it shall make an endeavor to assist the parties in the first instance in arriving at a settlement in respect of the subject matter of the suit. The second schedule related to arbitration in suit, while briefly providing arbitration without intervention of the court. Order 1, Rule 1 of the schedule says that where in any suit all the parties agree that any matter in difference between them shall be referred to arbitration, they may at any stage before the judgment is pronounced can approach the court for the order of reference. This schedule in a way supplemented the provisions of Arbitration Act 1899. How did this Arbitration Act came in India, that is 1899 Act? It was a substantially based on British Arbitration Act of 1889. It expanded the area of arbitration by defining the expression submission to means a written agreement to submit present and future differences of arbitration, whether an arbitrator is named therein or not. So British Act was of 1889, and after 10 years, the Indian Act in 1899 came into force, which was basically the same act which was applied to India. The Geneva Protocol on Arbitration Clause 1923 and the Geneva Convention of Execution of Foreign Arbitral Awards 1927 were implemented in India by the Arbitration Protocol and Convention Act 1937. This act was enacted with the object of giving effect to the protocol and enabling the convention to become operative in India. The Arbitration Act 1940 dealt with only domestic arbitration. Under 1940 Act, intervention of the court was required in all the three stages of arbitration in the tribunal. That is, prior to the reference of the dispute, that is, during the proceedings, and after the award was passed. This act made provisions for arbitration without court intervention, arbitration in suits, arbitration with court intervention in pending suits, and the arbitration with court intervention in cases where no suit was pending before the court of law. Before an arbitral tribunal took cognizance of a dispute, court intervention was required to set the arbitration proceedings in motion. The existence of an agreement and of a dispute was required to be proved. During the course of the proceedings, the intervention of the court was necessary for extension of time for making the award. Finally, before the award could be enforced, it was required to be made rule of the court. This act did not fulfill the essential functions of ADR. The extent of judicial interference under this act defeated its very purpose. It did not provide a speedy, effective, and transparent mechanism to address the dispute arising out of the foreign trade and investment transactions. Now we come to 1996 Act, the Arbitration and Conciliation Act of 1996, which was enacted by the government in an effort to modernize the 1940 Act. In India, the modern law has been adopted almost in its entirety in 1996 Act. The changes brought about by the 1996 Acts were so drastic that the entire case law built up over the previous 56 years on arbitration was rendered superfluous. Absence of a full-fledged arbitration bar effectively prevented arbitration being heard continuously on day-to-day basis over the normal working hours, that is 4 to 5 hours every day. This resulted in elongation of the period for disposal. It was also said in the ADR Congress held in the year 2010 that 1996 Act, although modeled along international standards, has so far proved to be insufficient in meeting the needs of the business community for the speedy and impartial resolution of disputes in India. The Law Commission of India prepared a report on the existence of 1996 Act and suggested a number of amendments. Based on the recommendations of the Commission, the Government of India introduced the Arbitration and Conciliation Act Amendment Bill 2003 in the Parliament. The Standing Committee of Law Ministry felt that provisions of the bill gave room for excessive intervention by the courts in arbitration proceedings. ADR can be classified into two categories. One is that court annexed options, that is mediation and conciliation. And the second is community-based dispute resolution mechanism, that is Lok Adalat. The following are the methods of ADR practiced in India: arbitration, mediation, conciliation, negotiation, Lok Adalat, and dispute review board, which is also known as dispute adjudication board. Arbitration In section 2(1)(a) is a verbatim reproduce of the text of article 2(a) of the model law. Arbitration means any arbitration, whether or not administered by a permanent arbitral institution. It is a procedure in which the dispute is submitted to an arbitral tribunal which makes a decision, that is an award in case of arbitration, on the dispute that is binding on the parties. It is a private, generally informal and non-judicial trial procedure for adjudicating disputes. There are four requirements for the concept of arbitration: an arbitration agreement, a dispute, a reference to the third party for its determination, and an award by the third party. The essence lies in the point that it is a forum chosen by the parties with an intention that it must act judicially after taking into account relevant evidence before it and the submission of the parties. Hence, it follows that the forum is chosen, if the forum chosen is not required to act judicially, the process is not arbitration. Now, types of arbitration in India: these are ad hoc arbitration, institutional arbitration, statutory arbitration, and fast track arbitration. Now, come to the second point: mediation. That is a process in which the mediator, an external person neutral to the dispute, works with the parties to find a solution which is acceptable to all of them. The basic motive of mediation is to provide the parties with an opportunity to negotiate, converse, and explore options, aided by the neutral third party, to exhaustively determine its settlement if the settlement is possible. Mediation is negotiation carried out with the assistance of the third party. The mediator, in contrast to the arbitrator or judge, has no power to impose an outcome on the disputing parties. The Arbitration and Conciliation Act 1996 is framed in such a manner that it is concerned mainly with commercial transactions that involves the common man rather than the common man's interest. Conciliation. Conciliation is a process in which a neutral person meets with the parties to a dispute which might be resolved, a relatively unstructured method of dispute resolution in which a third party facilitates communication between the parties in an attempt to help them to settle their disputes. Section 61 of 1996 Act provides for conciliation of disputes arising out of the legal relationship, whether contractual or not, and to all proceedings relating thereto. After its enactment, there can be no objection for not permitting the parties to enter into conciliation agreement regarding the settlement of even future disputes. Now comes to negotiation. Negotiation is a communication for the purpose of persuasion, is a preeminent mode of dispute resolution. Compared to process using mutual third party, it has the advantage of allowing the parties themselves to control the process and the solution. Essentials for negotiation. It is a communication process. It resolves conflicts. It is a voluntary exercise. It is a non-binding process. Parties retain control over outcome and procedure. There is a possibility of achieving wide-ranging solution and the maximum joint gains. In India, negotiation doesn't have any recognition. Negotiation is counseling between the parties to resolve their disputes. Now, next point comes to Lok Adalat. Lok Adalat is a historic necessity in the country like India, where illiteracy dominated other aspects of the governance. It was introduced in 1982 and the first Lok Adalat was initiated in Gujarat. The evolution of this movement was a part of strategy to relieve heavy burden on courts with pending cases. It was the concept of social justice, speedy justice, conciliated results, and negotiating efforts. It is a suitable alternate mechanism to resolve disputes in the place of litigation. Lok adalats have assumed significance statutory recognition under the Legal Services Act 1987. And the last point about the ADR processes is the dispute review board or the dispute adjudication board, as you call it. The primary function of the dispute review board is to assist the parties to construction contract and avoid dispute by facilitating and improving communication and encouraging the resolution of continuous issues by the parties at the job level before they become disputes. If the issue cannot be resolved at a job level, to assist the contracting parties to resolve the disputes quickly and cost effectively without the need for arbitration or litigation. In the first instance, the dispute review board can informally assist the parties if they so require to resolve any disagreement which arise during the course of the contract works. The members can make recommendations or decisions regarding issues and disputes referred to them by any of the contracting parties. The primary advantage of standing dispute review board as opposed to the ad hoc appointment of an adjudicator or arbitrator is that whenever the dispute arises, the members of the dispute review board will have a high degree of knowledge of or familiarity with the project, the contractual context, its progress, which enables the dispute review board to assist the parties informally by providing recommendations or, if required, to render a decision within relatively a short period of time. Dispute Adjudication Board and Dispute Review Board. DAB and DRB are widely used as ADR mechanism in construction dispute. Standing panel consists of 3 members or 5 members will be constituted for resolving the dispute. The only difference between the DAB and DRB is that the division of the DAB will bind the parties, whereas the DRB decision will not bind the parties. The members of the panel must have expertise on the subject matter of the dispute. In USA, DAB and DRB are used in tunnel projects, railways, highways, buildings, and process contracts involving the variety of employers, including American Telephone and Telegraph, the Hawaiian Department of Transportation, and the International Monetary Fund. Some institutions have included DAB and DRB model clause in their standard form of construction contract. For example, FIDIC has included DAB and DRB as a primary dispute resolution mechanism in its various model standards form contracts. American Arbitration Association and International Chamber of Commerce have their own dispute board rules. Part 2 of UK Construction Act has compelled the parties of certain specified construction contract must resolve their dispute through mandatory adjudication. The Chartered Institute of Arbitrators have formed the dispute board rules for providing DAB and DRB services to the disputants. Interestingly enough, I'm the first lawyer in the country to have done the dispute review board's matters in 1994 and for which my name came in Limca Book of Records. Now, coming to Legal Services Act 1987, which was brought into force on 19th November 1985. The object of the Act was to provide free and competent legal services to the weaker sections of the society to ensure that opportunities for securing justice are not denied to any citizen. The concept of the legal services, which includes Lok Adalat, is a revolutionary evolution of resolution of disputes. Though the settlements were affected by conducting Lok Nyayalas prior to this act, the same has not been given any statutory recognition, but under the new act, a settlement arrived at the Lok Adalat has been given the force of a decree which can be executed through the court, as if it is passed by it. Section 19, 20, 21, and 22 of the Act deals with the Lok Adalat. Section 20 provides for different situations where cases can be referred for consideration of Lok Adalat. Delhi High Court has given a landmark decision highlighting the significance of Lok Adalat movement in the case of Abdul Hassan and National Legal Services Authority versus Delhi Vidyut Board and others. The court passed the order giving directions for setting up of the permanent Lok Adalat. National Consumer Dispute Redressal Commission, in its judgment of Aftab Singh versus MRMGF Land Limited and another, discussed at length the issue whether the Arbitration Act mandates consumer forums constituted under the Consumer Protection Act 1986 to refer parties to arbitration in terms of a valid arbitration agreement, notwithstanding other provisions of the Arbitration Act and the Consumer Act. In A. Swami versus A. Paramshwam, Justice D.Y. Chandrachud had held that certain category of disputes as a matter of public policy are assigned to the public fora and those are excluded from public fora and authoritatively opined, the forum will not be barred to entertain complaint under the Consumer Act and has observed as under. I am quoting from the judgment. Hence, in addition to various classes of disputes which are generally considered by the courts as appropriate for decision by the public fora, there are classes of disputes which fall within the exclusive domain of the specific fora under the legislation which confers exclusive jurisdiction to the exclusion of an ordinary civil court. That such disputes are not arbitrable with the general principle that a dispute which is capable of adjudication by an ordinary civil court is also capable of being resolved by arbitration. However, if the jurisdiction of an ordinary civil court is excluded by the conferment of exclusive jurisdiction on a specified court or tribunal as a matter of public policy, such a dispute would not then be capable of resolution by arbitration. Section 3 of Consumer Protection Act states that the provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. The act protects the rights of the consumers and the remedy provided under the act is in addition to the provisions of any other law. In many other leading cases, it has been the object to understand the preamble of the act, and as the act is a social legislation to protect the rights of the consumer, it becomes necessary for the courts to interpret the act in some sense. The arbitrary nature of the consumer disputes will nullify the main object of the act, as the consumers will have to fight for its right in arbitration, which is pro-corporate, and it ends the meaning of the formation of the Consumer Redressal Forum. From the preamble of the Consumer Protection Act 1986, it is apparent that the main objective of the act is to protect the rights and the interest of the consumers by providing mechanism through which cheaper, expeditious, easier, and effective redressal is made available to the consumers. Supreme Court has held and observed as under. The preamble of the act declares that it is an act to provide for better protection of the interest of the consumer and for that purpose to make provisions for the establishment of the Consumer Council and other authorities for the settlement of the consumer disputes and matter connected therewith. As per the amendment, Section 8.1 of the Arbitration and Conciliation Act 1996, the forum should be judicial authority before which the parties applies for arbitration, should refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. The language of the amended section clearly states that the dispute should be referred to the arbitration if a party applies to a judicial authority unless the judicial authority finds that no valid agreement exists. The Supreme Court of India in Fair Air Engineers Private Limited and another versus N.K. Modi, while holding that the consumer forums were judicial authority, inter alia observed that it is seen that Section 3 envisages that the provisions of the Act are in addition to and are not in derogation of any other law for the time being in force. It is true, as rightly conceded by Mr. Suri, that the word in derogation of the provisions of any other law for the time being in force would be given proper meaning and effect if the complaint is not stayed and the parties are not relegated to the arbitration. The Act purports to operate in derogation of the provisions of the Arbitration Act. Prima facie, the contention appears to be plausible, but on construction and conspectus of the provisions of the Act, we think that the contention is not well founded. Parliament is aware that the provisions of the Arbitration Act and the Contract Act 1872 and the consequent remedy available under Section 9 of the Code of Civil Procedure, that is, to avail of right of civil action in a competent court of civil jurisdiction. Nonetheless, the Act provides the additional remedy. Any dispute between the private parties can be adjudicated by arbitrators as per the choice of the parties, as long as the disputes are not barred by legislation. The Supreme Court of India, in the case of Booz Allen and Hamilton Inc., SBI Home Finance Limited, explained the conceptual framework of what kind of disputes are arbitrable and non-arbitrable. Adjudication of certain categories of proceedings are, rev- are reserved by the legislature exclusively for public fora as a matter of public policy. Certain other categories of the cases, though not expressly reserved for adjudication by the public fora, courts and tribunal may be necessary implication stand excluded from the preview of the private fora. Consequently, where the cause or the dispute is arbitrable, the courts where a suit is pending will refuse to refer the parties to the arbitration under Section 8 of the Act, even if the parties might have agreed upon arbitration as the forum for settlement of such disputes. The courts are required to draw a line what is arbitrable and what is not arbitrable by ensuring that sensitive matter of public interest falls within the principal jurisdiction of the courts and disputes between private parties can be freely chosen to do arbitration rather than litigating their differences. Supreme Court in various decisions has interpreted Section 3 of the Consumer Protection Act and has held that the act is enacted with an object to provide for better interest of the consumer, and for this purpose the consumer councils have been established so that the interest of the consumers can be protected by providing for better redressal. Mechanism through which the cheaper, easier, expeditious, effective redressal is made available to the consumers. The courts in Aftab Singh Supra further held that the Consumer Act was envisaged as a special social legislation to protect consumer rights, unlike other legislation that creates dispute resolution mechanism between level players. This legislation established a level playing field between unequal players, that is consumer and large corporations. The larger bench of NCDRC, that is National Consumer Dispute Redressal Commission, while deciding the issue, held that if the arbitration is allowed, it would prove to be against the entire purpose and the object of the act, that is to protect the interest of the consumers by ensuring speedy, just and expeditious resolution of the dispute of the consumers. Exposure of consumer dispute to the arbitration will invite application of Arbitration Act which is enforceable through civil code, which would be against the purpose of the Consumer Act. The courts further concluded that the statutory enactment which are established with a specific purpose to adjudicate and govern specific disputes are not arbitrable, and there are vast domain of the legal universe that are non-arbitrable and kept distance at a distance from private dispute resolution. Presently, the case has been taken up by the Honorable Supreme Court to explain the correctness of the decision of the larger bench in NCDRC in Aftab Singh versus MGF Land Limited and another, which has held that the consumer disputes cannot be settled by arbitration. The Honorable Supreme Court should find a balance towards the applicability of both the acts so that the legislature, philosophy, and social objective of the Consumer Protection Act 1986 and Arbitration and Conciliation Act 1996 could be achieved while protecting the interests and rights of the parties. At the end, I would like to conclude by saying that with the advent of the alternate dispute resolution, there is a new avenue for the people to settle their dispute. The settlement of the disputes in Lok Adalat quickly has acquired good popularity among the public, and this has really given rise to the new force of ADR, and this will no doubt be reduced the pendency of the law courts. There is an urgent need for justice dispensation through ADR mechanism. The ADR movement needs to be carried forward with greater speed. This will considerably reduce the loads and the courts, apart from providing instant justice at the doorstep without substantial cost being involved. If they are successfully given effect, then it will really achieve the goal of rendering the social justice to the parties to the disputes. Thank you very much. Thank you very much, everyone who have spared their time to listen to me. Thanks a lot.
So now we must take up certain questions from the audience as well,
Sure.
if you agree.
Yes, yes,
Yeah.
sure.
So the first question is, can you please mention any milestone case relating to arbitration?
There is not one. There are several. Very recently, I had conducted a case of arbitration which was involving 27,000 crores rupees. 27,000 crores of rupees, in which the service tax itself was about 650 crore. So there are big matters which are decided through arbitration and through a ADR mechanism.
Okay, sir. The next question is arbitration award legally binding upon parties?
Of course, of course, the award is legally binding on the parties after 1996 Act, Arbitration and Conciliation Act, which has come in 1996, which replaced the 1940 Act. As I mentioned that I had conducted cases under both the acts. 1940 Act also I had conducted cases, 1996 also I am conducting cases, and further amendments and everything. See, in 1996 Act, the basic change which was made was the requirement of making award as rule of the court is not there. So the arbitration award itself becomes a decree and enforceable. Whereas in 1940 Act, the award was to be made rule of the court. There was another process after the award. So therefore, the award under the 1996 Act are fully enforceable.
Okay, sir. The next question is, can respondent appoint an arbitrator after expiration of 30 days time period?
Yes, there was a provision in 1940 Act that both the parties could decide as to who will be the arbitrator And of course, the respondent in many cases where the respondent was the owner or the corporation or the government could appoint the arbitrator of its choice, and in many of the cases these officers were of their own organization. But under the 1996 act, this power of appointment of the arbitrator is lying with the parties if there is a provision in the agreement that who will be the arbitrator. Otherwise, if they fail to appoint an arbitrator in such a case, the parties, the petitioner can go to the court and can request for appointment of an independent arbitrator rather than the agreed person. So they can do that.
Okay, sir. So right now there is a question that can you please name the parties which were involved in the case you just mentioned, covered the 27,000 crore amount?
No, it is not appropriate to mention the name of the case because it will come out to be an advertisement of my work. So that will not be appropriate. I don't want
Yes,
to
sir.
advertise myself. Yes.
It's okay. It's okay, sir. So,
Yes.
is
I
arbitration
have,
suited to
in
Indian
fact, I
soil?
have the
And if
award.
yes, then what are the practical problems?
One second, I was saying something. If
Yes, sir.
someone is interested in
Yeah, yeah, sorry, sir.
knowing the outcome and the parties, they are most welcome to come to my office on prior intimation. The award is also there. The whole record is there with me in several volumes. They are also always welcome to work and study. If one can study that case, I think he will become a good arbitration counsel in one case itself. Yes. Next, your question. Please repeat your
Okay, sir.
question now.
That's good to know. Yeah,
Yes.
yeah. Is arbitration suited to Indian soil? And if yes, then what are the practical problems in the smooth run in India?
Arbitration, of course, as I said, that I started from the ancient time that the arbitration suited the Indian soil, and it is very much suitable to Indian environment. And there are a lot of cases which are being decided through arbitration. As I mentioned, a very big case, but there are not only one case, there are many big cases which are being decided by arbitration. So arbitration is very much suitable to our Indian, environment.
Okay, sir. Okay, sir. So the next question is, being an arbitrator, mediator, or conciliator, what a person can expect from future?
There is a lot of scope in this field, and the arbitration is now picking up pace with time, and not only in India but around the whole world. Even in Brazil, if I look at it, there are several cases which are coming up for arbitration. So if one opts to be an arbitrator or mediator or conciliator, I would say arbitrator, because the arbitration is something which is binding. Mediation is not binding, as its effect is not that of arbitration, at least in India. So there
Yes, sir.
is a scope, but provided somebody is competent to handle it and somebody gets an opportunity to do it, because getting an opportunity is something,
Okay,
for a
sir.
new person to getting an opportunity to be an arbitrator is quite difficult, because it requires lot of technicalities, lot of experience. As I mentioned, that case, if someone can come and study, he will become a good counsel in arbitration, is only because there were several provisions of law of several acts, including limitation, including service tax act, including civil procedure code, even evidence act. I mean, there were Indian contract act, and other there were several other acts. If one can go into the details of that arbitration, he will be conversant with all the acts. But I think for a new person to understand and study the whole case, it might require 4 to 5 months time. So there is scope in the
Okay,
field
sir.
of arbitration, lot of scope.
Okay. Okay, thank you so much, sir. The
No
next
problem, no
question, it is the
problem.
last question we are taking up for today. So it is that, is arbitration being taken up by litigants during the current situation of
Yes,
COVID also?
yes. Rather, when the traditional courts
Okay.
are nowadays closed, most of the courts are closed for physical hearing, only virtual hearing is permissible. Yes, arbitration is being taken up through virtual hearing only. But arbitration is, we have been doing a lot of arbitration during this COVID period. In last 8 to 9 months, we have been doing a lot of arbitration cases through virtual hearing. So this is one of the best option to resolve the dispute during this pandemic period.
Okay, sir. Okay, so that was the last question. Thank you very much, sir, for enlightening us on this topic. And I thank the entire team of Law Tales for being able to conduct the webinar so efficiently, and attendees for their valuable presence.
Thank you so
Thank you
much.
so much, sir, for giving us such invaluable information and answering all the questions which were coming up. Now, one of the representative will be dropping the feedback form in the chat box below, and all the attendees are requested to please drop in their valuable response. Thank you
Thank you
everyone
so
once
much.
again. We'll
Thank you
see
and
you
all the
soon in the
best.
next
Thank you.
webinar. Thank you so much, sir.